Hi guys, and welcome to another episode of Attorney Javier's Law Lectures for Students. Today, we'll be having an overview, or as may be applicable, a review of the topic of insurance law. Okay, today's episode is part 1 of a 2-part series, and today we'll be discussing the nature, characteristics, and kinds of insurance. Note that as an overview or review, this discussion is more general in nature and some details may be omitted. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. This episode is brought to you by digest.ph, an online law library with over 80,000 case digests and Supreme Court decisions, all downloadable in Word and PDF formats. Use my promo code Javier Digest to get 20% off of Digest subscription plans. Now, let's begin. Now, the governing law on insurance is the Insurance Code, which has undergone several amendments from its first version under Presidential Decree number 612 up to its latest, which is Republic Act number 10607, which took effect in 2013. Now, what is insurance? Section 2 of the law defines a contract of insurance as an agreement where one party, known as the insurer, undertakes for a consideration known as the premium to indemnify or pay another party, known as the insured, for having suffered loss, damage, or liability arising from the happening of an unknown or contingent event, which is known as the peril that is insured against. So, there are two parties to the contract. We have the insurer and we have the insured. On the one hand, the insured applies for an insurance policy with the insurer to protect himself against loss, damage, or liability arising from an unknown or contingent event which carries the risk. For example, a person may apply for property insurance to protect his house from loss or damage caused by fire of accidental origin. Or he may apply for life insurance on his life. So in case he suddenly dies, his children can still receive financial support from the insurance proceeds. Now, on the other hand, in exchange for the consideration paid called the premium, the insurer promises to pay the insured or his beneficiary if the peril insured against causes loss or damage to the insured. And who can be an insurer? Any corporation, partnership, or association, as long as it is duly authorized to transact insurance business. Now, the current law has removed individuals from the list of those who can be insurers, so take note of that. On the other hand, who can be the insured and apply for insurance? Now, it's anyone who with the capacity to contract and having an insurable interest in the life or the property that is being insured. And he has to be not a public enemy, meaning a state or its citizens who is at war with the Philippines. So, only the insurer or the insured are parties to the insurance contract. The beneficiary is not a part of the contract unless the beneficiary is the insured himself. Because the insured can name himself as his own beneficiary, or he may choose to name any third person as his beneficiary to receive the insurance proceeds, in which case, that third person is the beneficiary and is not part of the insurance contract. Now, the insured may choose anyone to be his beneficiary, any third person, except persons who are disqualified from giving donations to each other, because the beneficiary is like a donee who receives the insurance proceeds as a donation. So, following Article 739 of the Civil Code, the following cannot be the beneficiary of a life insurance policy. First, persons who are guilty of adultery or concubinage at the time of the donation. Second, persons guilty of the same criminal offense in consideration thereof. Or third, donations to a public officer or his wife, descendants, and ascendants by reason of his office. Now, once the beneficiary is chosen, the insured may still change the beneficiary, except when the insured has expressly waived the right to change the beneficiary, such in the case of an irrevocable designation. Now, an irrevocable designation of the beneficiary gives the beneficiary a vested right to the policy, which cannot be taken away without his consent. And therefore, it carries the following effects. The irrevocable designation carries the following effects. First, the insured cannot assign the policy to another because he cannot change the beneficiary. And if he assigns that policy to another, then the relationship with the beneficiary will be changed. Second, the insured cannot take the cash surrender value of the policy because, of course, that now goes to the beneficiary upon the happening of the event insured against. Third, creditors cannot attach nor execute on the policy. Fourth, the insured cannot add a new beneficiary. And of course, fifth, the insured can no longer change the irrevocable designation. Now, because an irrevocable designation of the beneficiary gives him a vested right to the policy, and because of the effects which I just listed, the designation of the beneficiary as irrevocable must be expressly stated in the policy itself. Of course, the named beneficiary loses any right to the policy if he is the principal, accomplice, or accessory in causing the death of the insured. In which case, the proceeds will now be distributed to the other persons named in the policy, and if none, then to the estate of the deceased insured. Now, what can be insured against? Following the definition, a person can insure himself against loss, damage, or liability arising from an unknown or contingent event. It may be a future event resulting in loss or damage, such as in the case of fire or in the case of life insurance, where the liability of the insurer depends on the happening of an event, respectively either destruction by fire or death of the insured, or it may also be a past event, the happening or non-happening of which is unknown to the parties at the time the insurance contract is perfected, such as in the case of marine insurance, where at the time the policy is executed, the parties do not yet know whether the subject vessel has already sunk or not. So, let's move on to the characteristics and nature of an insurance contract. Now, originally, it is the insured that bears the risk of loss because of an uncertain event, let's say fire. By acquiring or applying for insurance, the insured's payment of the insurance premium serves as part of his contribution to a pool of funds, which the insurer gathers from other people who are subject to and want to be protected from the same or a similar risk of fire. In exchange, the insured is relieved of the risk, which is now carried by the insurer, who promised to pay if the insured suffers loss because of fire. In reality, the insurer's assumption of risk is actually spread over and distributed over the pool of funds that was contributed to the insurer by the people facing that same or similar risk. In other words, People who are subject to the same or similar risk contribute their money to the insurer, who pools that money into a common fund, which will now be used to pay any contributor that has suffered loss or damage caused by the risk insured against. In this way, insurance is a risk spreading or risk distributing device. Thus, the nature of insurance is that it is a plan for dealing with risk and the resulting economic loss if the risk insured against happens. Specifically, the insurer's assumption of risk is part of a general scheme to distribute actual losses among a large group of persons bearing a similar risk. Now, with specific regard to property insurance, if a property is being insured, since a contract of insurance in this case is a contract of indemnity or reimbursement as a synonym, no? The insured is only entitled to recover the amount of actual loss in case of an open policy, meaning a policy where there is no valuation of the property stipulated, or in the case of a valued policy, he can only collect up to the face value of the policy as agreed upon by the parties. Why are there limits in property insurance? These limits serve to reduce the moral hazard in order to prevent the insured from profiting from the insurance contract. Okay, so he doesn't burn his own property, etc. Okay? Because the real purpose of a insurance contract, especially in property insurance, is to return the insured to the same situation he was before the loss. Okay? However, this is only true for property insurance because life insurance contracts are not contracts of indemnity. And as such, these are always valued policies because the amount fixed in life insurance policies will always be unrelated to the value of the actual loss. Why? Because you cannot place a price on human life. As for its characteristics, a contract of insurance is aleatory, executory, and conditional because the obligation of the insurer to pay the proceeds of the insurance arises only if the event insured against happens. An insurance contract is also voluntary, as it depends on the willingness of the parties to enter into it. It is also synalagmatic because both parties have reciprocal obligations of equal value to each other. An insurance contract, this is important, is also a contract uberrima fides, or one of perfect good faith for both parties. Okay? Why is this important? Because it creates the obligation to disclose material facts, and this will give rise to our later discussion on concealment, material misrepresentation, warranties, etc. Okay? Now, a contract of insurance is also personal, not only because it binds the parties to it and their assignees, but also because the insurer, in approving the contract, considers the personal qualifications of the insured. As such, insurance taken by one person will not apply to the interest of another in the same property or life insured. Note also that insurance contracts are almost always contracts of adhesion because most of the terms of the contract do not result from mutual negotiation between the parties. Rather, they are prescribed by the insurer in printed form, and the insured may simply adhere to the contract or reject it in its entirety. Okay, he cannot change the terms stipulated in that contract as a general rule. That's why it's a contract of adhesion. Now remember your oblicon, a contract of adhesion is not necessarily void. Rather, in case of doubt, the contract shall be interpreted strictly against the party that drafted it or that made it, meaning the insurer, and interpreted liberally in favor of the insured. Now, there are different kinds of insurance contracts. Okay, and there are three general classifications. First, Insurance against loss or impairment of property interests, whether existing or merely expected. Second, insurance against loss of earning power by accidental injury, sickness, old age, disability, death, or unemployment. And third, insurance against contingent liability, meaning liability for unknown causes to make payment to another. Insurance contracts may also be classified according to object, namely life or health insurance, property insurance, and liability insurance. Okay? So, life insurance under Section 181 is insurance on human lives and anything related or connected thereto, such as health. In ordinary life insurance, the insured pays a premium throughout his life, okay, and the beneficiary receives the proceeds upon the death of the insured. In a limited life or term insurance policy, the coverage is only for a temporary basis or a limited period. But in an endowment policy, the insured is paid a certain amount or the face value of the policy if he survives a certain period. And in case he does not, then the beneficiary gets the proceeds. In any case, life insurance may be made payable on the death of the person or his surviving a specified period or otherwise contingently on the continuance or cessation or end of life. As to persons covered, it may be individual life or property insurance, which covers only one person or his property, or it may be group insurance, which covers many individuals. We also have industrial life insurance. Okay, industrial life insurance, where first, the premiums are payable either monthly or oftener. Second, the face amount of the insurance is not more than 500 times the current minimum daily wage in Manila. And third, the words industrial policy are printed on the policy. Now, insurance may also be personal insurance, such as life, disability, or motor vehicle insurance, or it may also be business insurance, such as where a company insures the lives of its employees or insures its properties like factories or inventories. Moving on to non-life insurance, there are also several kinds. First, we have marine insurance, which is the oldest form of insurance and therefore cannot be given a simple definition. In fact, Section 101 of the Insurance Code gives a very long list of what is included in marine insurance. And broadly, we can say that there are three general types. There's ocean marine insurance, we have inland marine insurance, and we have aircraft hull policy, which is a type of aviation insurance. Some of the things that marine insurance covers include loss or damage to vessels, aircrafts, vehicles, and even freight or cargo that are related to or connected with risks or peril of navigation, even while they are being assembled, packed, or prepared for shipment. Of course, persons or property connected with or relating to marine, inland marine, transit or transportation are also covered, and even bridges, tunnels, piers, docks, and other instrumentalities of transportation and communication may be insured. Next, we have fire insurance, which under Section 169 includes insurance against loss by fire, lightning, windstorm, tornado, or earthquake, and if covered by extension or separate policies, other allied risks. Note that this only covers hostile fire or fire that has become uncontrolled, because there can be no recovery for the effects of friendly fire, which remain under the control of the insured, such as cracking, scorching, or soot, etc. Okay? Now, we also have what is known as casualty insurance, which under Section 176 is insurance covering loss or liability arising from accidents that are not included in the other types of insurance, such as marine or fire insurance. And under casualty insurance, we have employer's liability insurance, motor vehicle liability insurance, plate glass insurance, burglary and theft insurance, and other similar kinds of insurance. Next, suretyship. Okay? Suretyship is also insurance, which under Section 177 is an agreement where a party called the surety guarantees the performance by another called the principal or the obligor of an obligation in favor of a third party called the obligee. In other words, the surety promises to pay when the principal debtor does not pay. Unlike a guarantor in a contract of guarantee, a surety is directly and primarily liable to answer for the obligation because he binds himself solidarily with the principal debtor. Nevertheless, the liability of the surety shall be limited to the amount of the surety bond. Next, we have microinsurance, which under Section 187 is a financial product or service that meets the risk protection needs of the poor, subject to the following requirements. First, the amount of contributions, premiums, fees, or charges computed on a daily basis does not exceed 7.5% of the current daily minimum wage of non-agricultural workers in Metro Manila. And second, the maximum sum of guaranteed benefits is not more than 1,000 times the current daily minimum wage for non-agricultural workers in Manila. Next, we have compulsory motor vehicle liability insurance, or CMVLI, which is a protection coverage primarily intended to provide compensation for death or bodily injuries suffered by innocent third parties or passengers as a result of the negligent operation and use of a motor vehicle. Now, motor vehicle owners and operators, are required to secure CMVLI in order to assure the victims or their dependents of immediate financial assistance, regardless of the financial capacity of the motor vehicle owner or operator. Now, the last contract that we will discuss is what is known as the variable contract, which is any policy or contract on either a group or an individual basis that is issued by an insurance company that provides for benefits, other contractual payments, or values that vary so as to reflect investment results of any segregated portfolio of investments or of a designated separate account in which amounts received in connection with such contracts shall have been placed and accounted for separately and apart from other investments and accounts. This contract, this variable contract, may also provide benefits or values incidental and payable in fixed or variable amounts or both. In other words, this kind of insurance allows for investment opportunities, usually in stocks of publicly listed corporations that are traded over the stock market. So that's it for part 1 of our overview of insurance law, where we covered the nature, characteristics, and kinds of insurance. Stay tuned and subscribe for part 2 of our insurance overview, where we will discuss the elements, rescission, and claim settlement of insurance. Now, I hope you may have picked up a thing or two, and I hope to see you next time. See you soon. Bye.